As educators, this presentation will examine the rights that we retain and those that are restricted for educators, the specific constitutional laws that provide our rights, and the landmark cases that interpreted those laws will be discussed. As you remember, the basis of our inalienable rights are founded in the Bill of Rights, those first 10 amendments to the Constitution. Let's now review the foundation of those rights and the accompanying federal cases that interpret those rights for education. The First Amendment of the Constitution prohibits Congress from making any law that establishes a particular religion, ensures there are no prohibition on free exercise of religion, curtails the freedom of speech, infringes on the freedom of the press, or interferes with the people's right to peaceably assemble and petition the government for a redress of grievances. The two most applicable tenets in the First Amendment for staff rights in education are freedom of speech and freedom of religion. The first case to challenge the First Amendment and ask the legal question, can a teacher be dismissed for publicly criticizing school policy, was Pickering versus Board of Education of Township High School District 205. Here are the facts. Mr. Pickering, a high school science teacher at Townsend High School in Will County, Illinois, wrote a letter to the editor of a community newspaper criticizing the Board of Education's allocation of funds between academics and athletics. The school board terminated the teacher, saying that the letter contained false statements that impugned the integrity of the school system. The teacher sued, claiming the board violated his First Amendment rights by terminating him for exercising his right to freedom of speech. Pickering appealed the board's decision in state courts. After a narrow defeat before the Illinois Supreme Court, Pickering appealed the court to the court of last resort in this country, the United States Supreme Court. On June 3, 1968, the U.S. Supreme Court issued its decision in the case. The court voted 8-1 in favor of Pickering. Justice Thurgood Marshall wrote, "The problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting about matters of public concern and the interest of the state as an employer in promoting the efficiency of the public services if they are performing through its employees." The High Court noted that Pickering's letter to the editor referred to important matters of public interest in the community and that Pickering should not lose the rights he possesses as a citizen simply because he works as a public school teacher. Pickering was reinstated in September of 1969 and worked as a teacher at Township High School until his retirement in 1997. As a result, we educators must thank Marvin Pickering for his fight for our right to publicly criticize our bosses in matters of public concern. Mount Healthy City School District versus Doyle was the next landmark Supreme Court case that prompted First Amendment interpretation. In 1970, Doyle, a non-tenured teacher, was involved in several contentious incidents, including arguing with another teacher, quarreling with school cafeteria employees over the amount of spaghetti he was served, referring to students as sons of bitches, and making an obscene gesture toward two girls. However, the next incident broke the camel's back, so to speak. In February 1971, the principal circulated a memorandum to teachers regarding teacher dress and appearance, and Doyle conveyed the substance of the memorandum to a disc jockey at a Cincinnati radio station. When the teacher's contract came up for renewal, the school district declined to renew it. Doyle sued the Mount Healthy Board of Education in the United States District Court, claiming that the board's refusal to renew his contract violated his rights under the First and 14th Amendments to the United States Constitution. In 1977, the U.S. Supreme Court affirmed that the school had violated Doyle's freedom of speech and he was entitled to reinstatement with back pay. Clearly, had the radio station incident not been submitted as a reason for his non-renewal, the board legally could have dismissed Doyle on the other instance, which demonstrated his lack of tact in handling professional matters. The next landmark free speech case is Connick versus Myers, which began after Sheila Myers, who had worked for 5.5 years as an admittedly competent assistant district attorney, was informed by an assistant district attorney, Dennis Waldron, that she was being transferred to a different section of the criminal court. Attorney Myers protested to her boss, who was Harry Connick Sr., and other employees about her transfer. After talking with some of her co-workers, she drew up a questionnaire. When Waldron heard about the survey, Myers was told not to circulate the questionnaire, but she did it anyway. Connick, the father of now famous musician and television celebrity Harry Connick Jr., then informed Myers that she was being fired for her refusal to accept the transfer. She also was told that her distribution of the questionnaire was an act of insubordination. Myers brought suit in district court claiming that her First Amendment rights were violated. The federal court and the circuit court held for Myers, but the U.S. Supreme Court ruled 5-4 against her in the case because her actions were due to private interests, not public concern. Therefore, as recognized by the Supreme Court, not everything said in the public arena by a public employee gets First Amendment protection. It is also worth noting that although this case took place in a DA's office, it has bearing on education because the employment was in the public sector, as is education. For our world today, personal blog posts by a public school employee made off campus on her own personal computer may not be entitled to the protection of the First Amendment under some circumstances. Natalie Monroe, a Pennsylvania English teacher who called her high school students rude, lazy, disengaged whiners on her blog, was initially suspended with pay and then ultimately given her job back. But on the return, pupils were allowed to opt out of her classes, and she was left with a small number of students. The U.S. District Court of Appeals for the Third Circuit ruled by a 2-1 margin that although Natalie Monroe's blogs were on matters of public concern, they caused disruption at her school and that the Central Bucks School District's interests outweighed hers. Therefore, her firing was upheld. Each case in relation to internet presents a distinct set of facts when considering a teacher's free speech rights. In another situation, Lowry, a speech pathologist at Avalon Elementary in California, often posted on Facebook about statewide issues, such as education policies and standardized testing. She wrote the posts on her own time and did not write anything about her employer, co-workers, or students. After a series of posts, her supervisors told her that she would need to leave her position at Avalon and work at a school at the other end of the county, or work as a floater and fill in for employees who were on leave. A state employee relations board arbitrator wrote that Lowry's posts were written as a citizen on matters of public concern and did not negatively affect her work. Thus, she was reinstated to her Avalon school position. As you can see, with these differing circumstances, the debate still continues about how much free speech public employees have when they use school media, social media. Without question, this area of law is still developing. In a religious freedom case against religious discrimination in the workplace based on Title VII of the Civil Rights Act of 1964, the Supreme Court in Estonia Board of Education versus Philbrook clarified an employee's obligation to make reasonable accommodations for employees who request leave to observe their religious holidays. The court held the employer is obligated only to offer a reasonable accommodation to the employee and not obligated to accept any reasonable accommodation proposed by the employee. After this particular lesson on staff rights during one of my classes, Barrett, a student in class, told me that Steubenville City Schools refused to hire him unless he enrolled his child in their public school, although he was told that he was the best candidate for the job. Patrick Barrett, a substitute teacher in a public school in Ohio, brought this civil rights action against the school district where he was employed, challenging the requirement of Superintendent Richard Lucci that in order for Barrett to obtain a permanent teaching position, Barrett had to enroll his son in public school. Barrett's son attended a parochial school. When Barrett decided to keep his son in the private school, he was dismissed from the position. He filed a suit and charged that the defendants had violated his constitutional right as a parent to direct his child's education. Although not necessarily a freedom of religion case, the circuit court upheld the district court decision with majority ruling that a parent's right to direct the education of his or her child is clearly established as a liberty right. Barrett was granted an undisclosed monetary award. The next Bill of Rights for education to consider is search and seizure. The United States Constitution's Fourth Amendment allows government agents to conduct searches if probable cause exists and requires a warrant for an individual or property to be seized or searched by a government agent. New Jersey versus TLO is the seminal search case for schools. 2 students were found smoking in the girls' bathroom. One student confessed, but the other, TLO, denied smoking. In fact, TLO claimed she did not smoke at all. The school assistant principal then proceeded to search TLO's purse. In the purse, he found marijuana in small bags, rolling paper, a large amount of cash, and a list of names who owed TLO money. The police were summoned and TLO was arrested. TLO was suspended from school and later convicted on possession charges. TLO sued the school and claimed that the search of her purse violated her Fourth Amendment constitutional rights. The case eventually went to the U.S. Supreme Court. The Supreme Court ruled against TLO, establishing the new reasonable suspicion standard for school searches, which is less than required for police regarding probable cause. The interpretation of the Fourth Amendment gives school officials much broader search powers and limits a student's privacy rights. Interestingly enough, although this was a student search case, the court broadened the standard to apply to school employees as well. The O'Connor versus Ortega case involved a doctor employed in a state hospital where he managed the psychiatric residency program. Concerned about possible improprieties in the residency program, officials placed the doctor on paid administrative leave while an investigation was conducted. As part of the investigation, hospital officials on several occasions searched the doctor's office. They seized his personal property as well as property belonging to the state as evidence of wrongdoing and terminated the doctor's employment. Subsequently, he filed suit in a federal district court claiming Fourth Amendment violations. Ultimately, the U.S. Supreme Court upheld the warrantless searches by hospital officials and made it clear that public employees have a reasonable expectation of privacy in their desks and the cabinets. However, if the administrators are in search of work-related misconduct or need to retrieve work-related materials, then the warrantless search is permissible. In Shaw versus Cherry Value Springfield Central School District, a teacher sued a New York school district and several school officials for violating his constitutional right to be free from unreasonable searches and seizures under the Fourth Amendment. School officials suspended the teacher based on allegations of improprieties toward a female student. During the suspension, officials searched the teacher's classroom and a locked file cabinet, and they attempted to introduce some items that they found at the teacher's disciplinary hearing. The Second Circuit Court view found the search was reasonable and did not violate the teacher's constitutional rights. In Knox County Education Association versus Knox County Board of Education, a school board policy required all individuals applying for safety-sensitive positions to submit to a suspicionless drug test. Under the policy, all administrative and teaching positions, teacher aides, substitute teachers, bus drivers were designated as safety sensitive. The court upheld the school board's interests against school employee privacy interests and held that employee privacy interests are diminished in an environment where school safety and security are of paramount importance. The Fifth Amendment protects individuals from being compelled to be witnesses against themselves in criminal cases. However, in Berland versus Board of Education, Public Education School District of Philadelphia, a 1958 case, it was ruled that a teacher may not invoke their Fifth Amendment rights at a disciplinary hearing and may be compelled to answer direct questions. Refusal to respond to questions may be viewed as an act of insubordination. The Ninth Amendment to the United States Constitution is one of the least referred to amendments in Supreme Court decisions. It is also one of the most confusing, controversial, and misunderstood amendments to the Constitution. This amendment reserves all rights not listed in the Constitution to people, which include the rights to privacy, an important issue for employees today. In Erb versus Iowa State Board of Education, Richard Erb, an art teacher, became involved in an extramarital affair with Margaret Johnson, a fellow colleague at the school. Margaret's husband, Robert Johnson, filed a complaint against Erb. The board voted 5-4 in favor of revoking Erb's teaching certificate. During the trial, the board refused to allow Erb's attorney to cross-examine any witnesses in support of Mr. Erb's character and his fitness to teach. The Supreme Court held that the board acted illegally in revoking Erb's teaching certificate. The court also found that the board used excessive power by revoking the teaching certificate in retaliation to a teacher's in relation to a teacher's personal and private conduct. Evidence showed Erb to be a teacher of exceptional merit and that his affair did not affect his relationship with the school system nor teaching ability. Erb's teaching license was restored. In another privacy situation involving a Spanish teacher, Ginger Amico from Brownsville High School in Pennsylvania was suspended without pay for 30 days in January 2010 after photos of her with a stripper at a bachelorette party appeared on Facebook. The picture of D'Amico was posted on another person's Facebook page. An out-of-court settlement was reached between Brownsville Area School District and Mrs. D'Amico. The settlement outcomes were Ms. D'Amico's suspension was reduced to 19 days and she received $2,642 in back pay. Additionally, $10,000 from the district was split between the ACLU for attorney's fees and D'Amico for emotional distress. Finally, the school system removed all mention of the incident from her personnel file. and the Pennsylvania State Education Teachers Association dropped its grievance against the district. This case illustrates how advances in technology and social networking have raised questions about when public employers can discipline employees for off-duty behavior. The 14th Amendment contains the Equal Protection Clause and provides that no state shall deny any person within its jurisdiction the equal protection of the laws, and establishes that no state shall deprive any person of life, liberty, or property without due process of law. The Cleveland Board of Education hired James Loudermill as a security guard. On his job application, Loudermill stated that he had never been convicted of a felony. When it was discovered that Loudermill had in fact been convicted of grand larceny in 1968, the board's business manager informed Loudermill that he was dismissed because of his dishonesty in filling out the employment application. Loudermill was not given an opportunity to respond to the charge of dishonesty, nor to challenge the dismissal. Loudermill filed suit in district court alleging that the board removed his property rights of salary and fringe benefits without giving him a chance to defend himself in violation of his due process right under the 14th Amendment. The U.S. Supreme Court ruled in Loudermill's favor, stating that the Due Process Clause requires a procedure that carefully weighs the interests of employees to retain their jobs and outweighing the rights of the state to remove employees. This procedure must incorporate the essential requirements of due process, which are at minimum notice of the action and an opportunity to respond to the dismissal prior to termination.